to start with State of Ohio versus Terry Wade Hale. That's case number 29096. State of Ohio has waived oral argument in this matter, so we will just be hearing from Mr. Ludwig on behalf of Mr. Hale. Sir, you'll have 15 minutes to present your argument. And we've read the briefs and are prepared to proceed if you are, sir.
Thank you, Your Honor. If it please the court, my name is Mark Ludwig, and I am co-counsel assisting appointed counsel Rhonda Kotnick. By the way, Rhonda covered the first appearance I had in this case when I was appointed as trial counsel for Mr. Hale back in on May 20th of 2015. So we've both been working with Mr. Hale for some period of time. Mr. Hale was arraigned in common pleas court 4 years ago yesterday. He arrived in prison in July 19th of 16 with 53 days jail time credit. So he's now done over 3 years of a 9-year sentence, which has mandatory time for 2 reasons: prior convictions and vicinity of a school. This is an appeal of a denial of a motion for new trial that occurred without hearing. The notice of appeal here, you might note, was filed under the old appellate case number of 28334 after the motion for new trial was denied. But it was assigned this case number 29096 by the clerk. There are 2 jurisdictional questions that first arise. First of all, this ruling on motion for new trial takes place the day after the Supreme Court denied a pro se petition for leave to appeal. Unlike this court, the Supreme Court does not issue mandates when it denies a pending appeal. So the Supreme Court's denial on June 6th of 18, the day before the ruling for motion for new trial, was not filed here in this court until June 26th and has never been filed in the trial court. My concern is, does that mean that the trial court had jurisdiction at the time it acted? I have no explanation how the trial court knew, if it did, that the Supreme Court had denied the day before. The record...
Maybe the trial court was astute enough to be watching the docket? That's not unheard of.
It's not unheard of, Your Honor. I just don't know that that's what happened.
Okay.
The chronology might certainly apply that. But again, the mandate is the important issue. Even if the Supreme Court acted on the 6th, and you could see that on the Supreme Court docket, no mandate from the Supreme Court follows, and the system requires the Supreme Court entry to be filed in this court from which the appeal was taken. And that didn't take place until after. Now, the trial court may well have known of something, but knowing of something and knowing of something because a court speaks through its entries are 2 different things. I don't want it to be no jurisdiction. I want this case decided on the merits, but I think it's our obligation to at least take a quick look at that issue. The second issue on jurisdiction is the prior case, 28334. That case was decided in August of 17 on the first appeal and not reopened on March of 18. At the time those 2 decisions were made, there was no final order in the criminal case. The motion for new trial had been filed prior to the timely file, prior to the filing of the first appeal.
But doesn't the rule though say that the filing of the motion for new trial results in the appeal time not running? The rule doesn't say that the order appealed is not final. It just says the appeal time does not.
No, standing alone, the rule doesn't say the order is not final. Where the order becomes not final is because to be appealable, it has to be a final order where appeal time runs. It's not a final order. When you timely file a motion for a new trial, before the notice of appeal is filed, that judgment of conviction is not final. The trial court has authority, technically, to say, I'm going to go ahead and rule on it. Now, I think it's probably not what's normally done, because there is an argument that, untimely or not, the Court of Appeals says whether it's got jurisdiction. Not the trial court says, I take a look at what happened and I say the Court of Appeals doesn't have jurisdiction. So it is not one of the clearest areas of the law, and perhaps it's not, because all too often that motion for new trial is not timely filed before the first notice of appeal, or whoever's assigned the appeal takes a look at the court record and decides whether there's a motion for a new trial. And that apparently was either done and determined not to be important, or wasn't done here for that first appeal. Nevertheless, it remains our position that nothing decided in 28-334 in either decision can have res judicata effect in this case, because there was no final order when this court acted. To the extent I contributed to that by filing the motion to reopen, I can only admit my ignorance doesn't make it an appealable order. It wasn't. The remedy we seek in this case is specific performance of a plea agreement. There was a 3-year mandatory plea agreement reached where the sentence would be suspended pending appeal.
Counsel, isn't a plea agreement a recommendation to the court?
It certainly is. And that recommendation, Your Honor, can be rejected, and it can be rejected for all kinds of reasons. But one of the reasons plea arguments cannot be rejected is a blanket policy that is, number one, a blanket policy. I'm not going to consider a no contest plea. I don't consider them. Okay? I'm not going to consider bond pending appeal. I don't allow it. Those kinds of reasonings are not decisions that are implementing the agreement. They are not reasons to deny an agreement. I think your client's going to run. I think based on his criminal history, he's going to run. I'm not going to grant bond pending appeal. That's a reason, Your Honor. Right or wrong, it is at least an exercise of discretion. The exercise of discretion here was twofold on denying this plea agreement. Number one, I don't grant bond pending appeal. And number two, your client lives out of state. I'm sorry, New Philadelphia, Ohio is Ohio. He did not live out of state. The only stated reason in this record for denying the deal on bond pending appeal was he lives out of state.
He was late 90 minutes as well, I think she said.
He was, yeah. And in that discussion, he comes in scruffy, covered with oil, explaining that the car broke down. There is no delay in trial beginning because pleas on the other two defendants are taken, and he's jailed for that. The following morning, the prosecutor's late, and I asked for some kind of balance, some kind of equal protection.
How late was the prosecutor?
She was over 40 minutes late. And unlike Terry, Mr. Hale had called and I had reported his progress routinely to the trial court. Apparently the prosecutor had called, but no one reports to the defense counsel or to the defendant things are being delayed. As a result of that 90-minute delay, Terry's then told, when there's discovery violations, well, if you'd like a continuance and sit in jail, I'll give you one. That was one discovery violation. If, in fact, specific performance or remand for a hearing on whether we ought to have specific performance is not an awarded remedy, then the remedies we're asking for is an award of new trial. But not just a new trial where we end up back here arguing these same issues all over again. There are some limitations that ought to be put on that new trial. Number one, suppression. This case was a bare bones complaint, no prompt determination of probable cause forthwith, and a search warrant based on those two things. And we complained about that. And what I heard back on the second day of the suppression hearing, March 3rd, 15, at page 136 was, well, the complaints are moot, aren't they? After an indictment is returned. That's not true. The complaints are moot. They're the basis of the arrest. The complaints in this case are exhibits which show that there was, whoever made a determination when the swearing of the complaints, there never was a warrant issued ever on these arrest complaints. Not forthwith, not 48 hours. What I get in a ruling at the trial court on the suppression issue is, well, basically you're saying under Heston, if there's time to get a warrant, they should. Well, that was one of the things we were saying yes. But on December 15th, we briefed the supplemental authorities setting forth the leading cases of State versus Hoffman, our Ohio Supreme Court, saying that there must be a determination of probable cause and not just prima facie, on-their-face complaints that said he had drugs. There has to be some articulation of facts in the complaint, some minimal, nominal articulation. These are nothing other than recitations of the statute. In Hoffman, the court let the city of Toledo off the hook for their procedure because there was at the time a Sixth District case that said that might be okay. But the court made it clear in Hoffman, no more. The complaints in this state must have a recitation of some facts. We also cited the Riverside case. We've been down that road discussing Riverside with this court recently. That is, some determination of probable cause must issue forthwith or within 48 hours and a warrant for detention issued.
The last time we were down that road, it was not an Akron case. This is an Akron police case, correct?
Yeah, this is.
Isn't probable cause found, I agree with this, but it's the state of the law, I think, found by the clerk.
Yes, but if you look at the face of these complaints, the form that they're using at this time is a complaint that's sworn to by the clerk. Then it says, the bottom half of the complaint says, probable cause found, warrant issued. These are blank, Your Honor. They don't say that. So the procedure might not be across the board. It may only be in Terry's case. I'm not making a class out of this. The discovery violations of which we complain, lunch hour measurements. The officer went out on the lunch hour of the third day of trial and measured the distance from the house to the school and said, here's part of our proof that this offense took place within 1,000 feet of a school. The middle of trial. I had been screaming, as I apologize, I do here often, for record discovery, record disclosure of what we have, and yet it's an officer is allowed, because we were questioning that the auditor's bill showing who pays the real estate taxes isn't proof of distance. And the first answer we got when we raised that the morning of trial was the newly assigned prosecutor saying, oh, we gave him that. One of the reasons I asked for record discovery is to avoid this aggravation of he said, you said, they said. Put it on the record. Well, we asked for this discovery violation. We asked for this discovery. And at 168, the prosecutor who handled the case came in, and I thank her for this candor. She came in and she said, no, I never gave him that auditor's statement. That was never given. The other prosecutor, I don't doubt, thought it was, but it wasn't true.
Didn't the trial court, though, offer you the opportunity to have a continuance to review the stuff that's in there?
No. The opportunity for the continuance was as to an auditor's bill that was claimed to have been given to me. It fell on deaf ears when I stood there and said, I've never gotten it. Today is trial. Not only is today trial, but today is trial after my client has been summarily locked up.
So you're contending that what the judgment entry says that the court offered the defendant the most appropriate remedial solution and approved a continuance of the trial in order to allow the defendant's attorney an opportunity to thoroughly review the late discovery. That didn't happen?
No, I'm not saying that didn't happen. I'm saying the context of where it happened. And the context of where it happened was Her Honor believing the first prosecutor's representation that I had actually received that discovery.
Counsel, let me ask you a question.
I had.
Where's the harm to your client in that issue?
In that issue, it's proof of the school district. It's,
They had to prove it in their case.
they had to.
If they didn't put forth evidence of that element, there would have been, I would suggest, quite a good sufficiency argument. Would you agree?
A
On
sufficient.
appeal. If the state never put that in, either it would have been Rule 29 out, or you would have had a good sufficiency argument because the state missed the element.
Well,
If they didn't put forth the element.
oh, if they didn't, yeah, Your Honor, that would have been the end of that issue, and we may now well not be standing here because the mandatory stuff's knocked out, the merger arguments are even stronger. It's amazing what could be. That's very important.
All right, Mr. Ludwig, your 45 seconds overtime. I want to give you the opportunity to answer the questions of Judge Callahan. But you are out of time, so we'll take the matter under advisement, issue a decision accordingly, and you'll receive a copy of the decision from the clerk on the day it's released. Thank you for your argument.
Thank you.